Thank you.
SJC-11501, Commonwealth v. Edward G. Wright.
Yes, counsel, good morning.
Good morning, Your Honor. And good morning, Your Honors. Richard J. Fallon for petitioner appellant Edward Wright. Your Honors, this is a troubling case. From the very start, Alan Gregory Smalls, the suggested third-party culprit, was a serious suspect. Indeed, that very day that Miss Anderson was killed, Smalls told the police that he had been her boyfriend several years prior, that he had been with her most of that previous day, and that night, after an altercation, after being told by Miss Anderson that she was going home to sleep with the man next to her, it turned out to be Mr. Wright, Smalls admittedly told her, quote, "Don't go home because I'll be there when you get there," end quote.
So you're right. This was known from the very beginning that he was a serious suspect. These statements were known from the very beginning.
I know.
Were they used at trial?
Well, Your Honor, incredibly, defense attorney told Mr. Wright on the stand not to say that, even though it was admissible under two separate evidentiary, it's hearsay, but it's admissible as a present intent and as hearsay third-party culprit. But his own attorney told him, don't say it.
So have you waived your ineffective assistance of counsel claim with respect to that? I mean, maybe that was ineffective. I don't know. It's hard to go back 30 years.
Extraordinarily ineffective. But, Your Honor, this is both ineffective and a waived newly discovered evidence, because the key evidence,
But that's not
the
newly.
admission,
How is it? Go ahead.
it was newly discovered in 1986. I'll agree with you. It wasn't newly discovered in 2007.
All right, newly discovered 1986, shortly after this trial.
Yes, Your Honor, you're right, and that's waived. I'll agree. I'll agree. and maybe this
What's
can make-
waived? Which is waived?
Well-
What's waived?
Is it everything waived?
No, the ineffective assistance, Your Honor, well, ineffective assistance, both, whether they're waived or not, and I stand by, Randolph's a crucial case here, because of course Randolph says, all claims, waived or not, must be considered. And I'll agree, if newly discovered, if the cast real doubt upon the conviction, newly discovered evidence standard, if that's more favorable to a defendant than the default.
But this evidence was newly discovered.
Pardon me?
This evidence that you're focusing
Yeah,
on now, the
was
fact that
newly discovered.
Smalls made statements to
To Ms. Ramis.
to Ramis.
Maria Ramis, the
That was
admission.
1986.
Yes,
newly
Your Honor,
discovered.
it was, yes, Your Honor. But, and this is a concept, I look for a specific case, and this is a concept that you understand, but it's just funny to say.
But
Oh,
there's just different kinds of waiver here, too.
Yeah, well-
One of the issues of waiver is was it preserved? And that's not what we're talking about here, I don't think, is it? We're talking about the question of, could you have raised it at an earlier motion for a new trial? And the answer to that is yes.
Yeah, you're right. I'm not disagreeing with that, Your Honor. But let me put a hypothetical that I think you all understand. Okay, someone comes up, and a year after the trial, comes up with a newly discovered evidence argument. It's denied. 3 years later, they come up with a DNA exoneration. Now, is this court going to say, well, I'm sorry, you waived it. You had your first newly discovered evidence motion. You didn't present it, so you waived it, so bye-bye. No, that's not how it works, Your Honor. And again, I quote from Randolph. It says, although the public's interest in the finality of criminal convictions is weighty, it's not always paramount. And then they quote Amaral, the Fells-Akers case. Quote, we cannot rid ourselves by process alone of the possibility of error and of grave and lingering injustice. And it's 30 years later. But, Your Honor, and I know a lot of defense appellate attorneys don't like Amaral. It's the Fells-Akers, Justice Freed talks a lot about finality. But Justice Freed, in that case, also pointed out that the issue of the children maybe being misled by interviewers and having outlandish statements. He writes, well, that went through a trial. That was cross-examined at trial. In this case, none of the powerful third-party culprit evidence, came out at trial. Zero. None of it. And yes, Your Honor, I agree. 30 years later, if you don't have a grave and serious question about Mr. Wright's guilt or innocence, you're not going to overturn this. Of course not. But that's the point, that this testimony, and finally we have testimony in 2007 of Ms. Ramos, and we have testimony that Judge Saris, after hearing it, in a thoughtful discussion, said she found it credible, and she also found that the inclusion of Ms. Ramos's testimony makes it more likely than not that no reasonable juror would have found Mr. Wright guilty. Now, I agree.
And she
that
goes
that was-
on to deny the habeas petition.
You're 100% right, Your Honor. That was a
But we can go on with this forever.
That was, no, well, that was a procedural basis. And of course, you're not bound by what Judge Saris wrote. But however, I suggest this is the reasonable conclusion and that constitutes a substantial risk of miscarriage of justice. Now, you're right. You say, Your Honor, that you can go on forever. But certain cases, particularly murder cases where someone's been in prison for 30 years, even 30 years on, it is worth considering, is there a very serious question that he's guilty or innocent?
If I can turn you to the facts.
Sure.
Was there any evidence of the motive of this defendant to kill her? I know there was evidence of Small's motive, or at least you've presented evidence of Small's motive. What was the motive with regard to this defendant?
Of course, at the end of the case, the district attorney Wright, said she was there. Miss Moss, the mother of Arthur Turner, was in a home for shelter for battered women. So clearly, even though that wasn't appropriate for motive, clearly that was their basis of motive, that Mr. Wright is a violent sort of person. Of course, I don't think there was any other basis of motive, but of course, we have very...
Wasn't there the testimony of the
Turner.
who said that the defendant indicated that the victim had tried to shoot him?
Had shot him. I don't know. Well, that's very important. I'm glad you brought that up, Your Honor, because I think that's...
And he got mad and he
That's very
stabbed her.
important. That here's the supposed confession of Mr. Wright to Mr. Turner, that shots were fired, and then he stabbed her, and then he took the .305 out of Springfield. And those are, of course, false details. There were no shots fired, and the testimony was Mr. Vernal Archie had driven him. But what I find fascinating, and in reading the Commonwealth's brief, the Commonwealth tried to, undercut Ms. Ramos' testimony by credibility by saying, well, Ms. Ramos had testified that she heard the victim, Ms. Anderson, was cut from her throat to her privates. But that doesn't undercut Ms. Ramos' testimony at all, because Ms. Ramos was very clear, and you can read it in Appendix 274 and 275, that that's what she heard from the people around the crowd. And we know common sense tells you you're going to get all sorts of rumors. Well, don't the details of Mr. Wright's supposed confession to Turner, this notion that there was shooting and that took the .305, don't those sound exactly like the false detailed rumors? And the difference about Mr. Turner's testimony, the First Circuit called it key, and Judge Farris saw it strong. I don't find it strong at all. In other words, the difference is the Commonwealth says that Turner lied only once. In other words, and we all can agree, of course, he lied when he said, I couldn't recognize his voice later. I suggest, Your Honor, and defense suggests that Turner lied twice, that he lied about this confession, and then he lied about, and then trying to help, in a very poor way, trying to help Mr. Wright by saying, oh, well, I wasn't sure it was right on the phone. And I suggest that is very plausible and fits his incentive. Everybody's clear on the other side that Turner and Wright hated each other, and not surprising, because it was Turner's mother that Wright was going with. It was his nemesis. Wright had no incentive to confess to Turner, and Turner had every incentive to want to put this guy away forever. And indeed, first, and I didn't cite the particular page 535, I'm sorry, but first he mentioned to his sister, and then his brother came to Turner, and Turner said, I'm not going to the police. And then the police finally went down to where he worked, and he was temporary at the time, where he worked in the Correctional Institute, to get him. So what are you going to do if you think you might, say, oh, I was just lying, I was making up? You might lose your job. Mr. Turner might lost his job. And when he changed his story, Your Honor, I guess the Commonwealth's point is that, well, he was trying to help Mr. Wright get out, get back to his mother, get back with mother. Of course not. He hated the fact that I suggest, Your Honor, that he changed his story to help Mr. Wright because he felt pretty guilty about like he realized now this might be putting him away forever, but he didn't want to say I lied because he thought he would be charged with perjury. And of course, the district attorney at trial said, we're going to charge him with perjury. And so this was, he thought, by saying, well, somebody said he was Ed Wright, but I didn't recognize his voice. This was his way of like making a little line by a second lie, but not being vulnerable to perjury. So I suggest, Your Honor, the evidence is not strong at all, and I won't get into it, but I pointed out the expert witness, Mark Grant, how poor he was. And in fact, I did write the letter to the Hampden County, and I understand you have to ask for it, but you can look at those tiles, put them together, and it's Appendix 58. And if you look at it, the circular striations are another footprint. Anybody can tell that, Your Honor. Now, the review of a motion, denial of a motion to dismiss, is abuse of discretion, as Your Honor pointed out. But I want to point out two things.
Motion for new trial, I mean.
Pardon me?
Denial of a motion for a new trial.
I'm sorry. I'm sorry. You're right. Exactly right. That's what I meant, but I misspoke. First, you're in as good position as the motion judge to evaluate Ms. Ramos's testimony, which is obviously the key evidence here, because unfortunately she's dead. She'll never testify in front of a Superior Court judge, though, as we know, Judge Saris was a Superior Court. But second, Your Honor, the motion judge here really didn't evaluate her testimony at all, other than procedural. I mean, you can look at the decision. It says, for the reasons set forth in the Commonwealth's opposition, I conclude this failed to establish judge. The Commonwealth opposition is all about procedural issues, about waiver, it's about direct estoppel, and says not newly discovered, Your Honor. But those procedural issues don't bar you from reversing and barred from being overturned, Your Honor, because it's not direct estoppel. There are two key new things here. There's not only testimony from Maria Ramos and a lot of key new details, but there's a new evidentiary reason. And it's just like, when you have overturned for jury instruction errors, there might not be new evidence, but there's surely new legal reason to overturn. Here, it's the first time this motion, the third-party culprit evidence, has been presented to the court to present a base to get into her testimony.
So what is this trial going to look like? Is it going to be a rereading of the transcripts of the 1985 trial plus a reading of the transcript of Ramos's testimony in the federal court? Is that what the trial is going to be?
Well, Your Honor, I'll agree. One of the points you might say, well, it might be more difficult for the Commonwealth. And I'm not going to disagree with that, but I'll also point out that it might well be more difficult for Mr. Wright, too. There's a lot of powerful third-party evidence. I'm not sure he's obviously not going to have Miss Ramos. I don't know about Miss Britt. I don't know about Miss Harris. That's key evidence about the knife, the fact that this fellow, Alan Gregory Smalls, was trying to sell a knife a few hours after he was killed. I don't know about Lee Britt's husband, who it didn't come out at the first hearing other than in hearsay point, but the husband had said that, well, you know what I'm going to say, that
He came home much later.
that he lied, that Alan Smalls lied. I don't know if he's going to be available. So I'll agree. You're right. It's going to be hard for the Commonwealth, but it's going to be a lot harder for Mr. Wright. It's not to Mr. Wright's benefits to have 30 years later incarcerated to be in front of you now. That really doesn't help him either. So I'll agree with you, Your Honor. I mean, what we have here is a situation 30 years after we know who had the motive and incentive. I mean, we know that's Alan Gregory Small. We know why, because he was still sexually obsessed by Miss Anderson, that he told Penny Ramos that she's mine and only mine, that she publicly humiliated that night. And, Your Honor, we've got a situation where Mr. Smalls threatened Miss Anderson that night and then confessed to Mary Maria Ramos that he had followed through with that threat. I mean, I don't know, have you ever seen third-party culprit evidence like this any time before? And, Your Honor, none of it came at trial. Now, I agree, after 30 years, the only reason you should be overturning this conviction is if you have a serious question of whether Mr. Wright is guilty or not. But I suggest to you that Maria Ramos' testimony, and viewed by Judge Saris and considered credible by Judge Saris, is such a serious question. And therefore, you should reverse the denial of the motion for new trial.
Thank you, counsel.
Thank you.
Good morning, Your Honors. Diane Dillon, an Assistant District Attorney representing the Commonwealth.
So tell us why we shouldn't have a serious question with respect to the defendant's guilt at this
Well,
point.
I'd love to tell you why. First, Maria Ramos's testimony before Judge Saris is totally incredible. And if you go back to the very beginning, when allegedly she told Miss Britt was very, very specific about, I went down to Florida on April 20th, just a couple weeks after the trial, and I visited my son who was living with Maria Ramos down there. And Maria Ramos told me that one night they were having this alcohol-fueled fight, and he said to her, I'll kill you just like I killed Penny, period, the end. That's in the middle of a fight. They always fought, and she said she gave as good as she got. That's what she said before Judge Saris, that she gave as good as she got. There's no evidence that this was a threat, and if considered in that context, I would suggest that it's not. If you look at what was said afterwards, specifically in 1999, when she talked to the Brooks, the private investigator.
Mrs. Ramos.
Ramos. She is all over the lot about where she lived, when she lived there. And Judge Sossman looked at that, and she, in her footnote, says 1982, 1984, where were they? When did they move to Florida? You couldn't even tell from what she was saying to the private investigator, and that's at, I think, pages 218 through 220-something, when she moved to Florida, but she was consistent about this all happened in late April of 1985.
Can I ask you, at the hearing before Judge Saris, was all this brought out by the Commonwealth on cross-examination, all the reasons not to believe Ms. Ramos?
No, Your Honor, because they were there for another reason.
But I mean, at the conclusion of it, though, the experienced Judge Saris found Ms. Ramos credible. So wouldn't her credibility have been
Binding?
No, I'm not saying about being binding. I'm just saying that, if that's what's at stake, whether the judge is going to find her credible, wouldn't you presume that the Commonwealth would have basically cross-examined her to make her, on all of these details that you're saying, make her not credible now? Were they brought out before Judge Saris?
No.
No.
They were not. It was the Attorney General's, and it was a different kind of hearing. And I'd like to say procedurally why I think this may be important, because what she was doing on the habeas corpus in the actual finding is looking at the whole case holistically, as it says in Schlepp versus DeLeo. And you don't have any regard to whether or not the evidence would be admissible at trial. Because
Well, but you're talking about credibility. That doesn't go to admissibility.
I'm going on to something else, because it doesn't have to do with admissibility when she's doing that in the federal court. When we're looking at a motion for a new trial, here in the state court, whether or not it's admissible is important. And you can find that at page 799 in Commonwealth versus Wetchell. The defendant has the burden of proving the evidence he wants to admit is admissible. Now, he's talking about sexual obsession. There is absolutely no
Okay, on admissibility, why would, why do you say it's not admissible?
Well, the one statement, perhaps, that he said to me, I'll kill you like I killed Penny, that might be admissible. The rest of it is mumbo-jumbo. She is all over the lot. She even says at one point before Judge Saris, because Judge Saris said, well, didn't you break up with him at least after that? And she said, well, I was very concerned, and so as a result of that, I called her up, and I said, is Greg home? And his mother said, no, Greg was at work. So I went over there and I told her about this.
Yeah, but certainly as a prosecutor, you're not going to say that the mere fact that a woman who's being battered goes back to a man means that what she says is not credible. Are you saying
No,
that
that's
to
not
us?
why I'm saying that.
Okay, I mean
no.
that argument to me is wholly untenable.
And it's not what I offered you.
Okay, so what are you offering? The fact that she went back to him means that he didn't say that?
No, it means that everybody else always said that when Lee Britt went to Florida on April 20th, 1985, that's when Maria Ramos told her face-to-face about what her son had allegedly said. And what Maria Ramos said before Judge Saris is that she called Lee Britt, who lives in Springfield, and said, is Alan home, which would put it in Springfield, and then she went over to her house and told her.
But,
Now, those are...
but I guess where I'm troubled is if you've got recorded testimony in which she was cross-examined, whether a particular detail is or isn't credible doesn't go to its admissibility, does it?
No, it's the tenor of it. I'm not arguing just a detail. That was just sort of the coup de grace when I got to the end of her testimony. What I'm arguing as far as that is concerned, and I don't think it's the most important argument, is that what Judge Saris was looking for isn't what we look for here in this Commonwealth of Massachusetts as far as evidence that might be admissible or grounds for a motion for a new trial.
Now,
And
how about the naked photographs of the victim on the wall?
how many naked photographs were there? Was there one? Were there more bikini things? I mean, and she took them down and she put them away, and there's no evidence that ever came back. Her opinion that he was sexually obsessed kind of fits in with her opinion of how Maria was murdered, Penny was murdered.
Okay, so put aside her opinion, but the mere fact that this
Well, if it's her
gentleman
opinion,
had
it's not
had the
admissible.
naked photographs of a woman who had said that she was going to go have intercourse with somebody, and then he said, "I'm going to be at your house." That is not admissible.
Let's look at this. 20-some-odd years after the murder, Maria Ramos talks about the photographs. That's never come up before. Everything else has come up before. I mean, this verdict was 29 years ago today. 14 months later, there are 2 motions for a new trial filed, one by the attorney and one pro se. And the one by attorney, he said Alan Smalls might have done it. And the one pro se, and you look on page 149 and 151 of the appendix, the defendant says another perpetrator. Now, if that's not third-party culprit evidence or grounds for it, what is? Somebody else did it. That's what he was putting forth in the new trial. He had a hearing in October of 1986, and he presented Lee Britt. Lee Britt alone, and she wasn't even going to testify, and she was mixed up on this. She has no evidence about the knife. She has no evidence about the sneakers. She had no evidence about the goods. I mean, she's saying that her son had some stolen goods from Penny's apartment. There is no evidence of a theft from Penny's apartment. And the police weren't there just on the 14th, the day of the murder. They went back several times, and they went back with Mark Grant. She lived on the 2nd floor. If there had been a break, the only evidence of anybody, or Ellen Small specifically, having Penny's goods is when she dropped her purse at the club. Before she left with the defendant, he picked up some things from the floor and he put them in his pocket. That's what the defendant said. Now, they didn't present evidence that was credible to the trial judge who had heard all of the evidence. He said it was mostly hearsay, as it was.
But just on that,
Yeah.
it does seem to me, and even with Justice Sussman's opinion, that the issue of what might be admissible in terms of hearsay on a third-party culprit theory was never presented until this motion. I think
Could have been presented in that case because he went back on reconsideration.
I'm
But
just saying none of the
Well, it's not just that, it's opinion. I mean, where's the foundation for a connection to the knife? Where's the evidence that he had a knife? It's not there. Lee Britt says, my daughter told me that he was trying to sell a knife. So she tells apparently her other daughter, who goes and buys the knife, and then she calls the DA's office, and then she calls the police, and she was told by the DA's office, this is right in her testimony, if you know these things, if you have this evidence, bring it in. And she never did.
Well, there
And the
was some
defendant
knife that was
has the
tested, right?
burden.
Wasn't there a knife that was tested and the testing was inconclusive?
It was inconclusive.
What knife was that?
It was a knife that she presented to the defense attorney a year after the trial.
Well,
Where did it come from?
Well,
We
I
don't
don't know.
know.
I don't know why
Well,
you're-
somebody should have told us 20-some-odd years ago. There's no foundation for the knife. She went to the trial. She became obsessed with the trial. She went down and started visiting the defendant in prison. And then she comes up with a sneaker, and you can look at the picture of the sneaker. The bottom of the sneaker she found in her son's room doesn't look anything like the bottom of the sneaker that was taken from the defendant. There's a picture right in the appendix. I think it's at 141. They're different. So we've woven...
It seems to me that your complaint, and is an understandable one, is that all of this could have been resolved one way or the other 28 years ago, and the defendant didn't.
And the defendant has an obligation.
Not newly discovered, this is waived 13 different ways. It's now reframed as a slightly different evidentiary issue, but the substance of it hasn't changed. But does that mean we give it no review at all?
Well, you can review it to find that it's inadequate under the standards that we apply here in the Commonwealth of Massachusetts. I think that Justice Freed was very eloquent when he was talking about this. He said that the consequences of criminal actions are so awesome and so devastating that when we initiate charges, all the presumptions and all of the procedures are designed to make sure that the Commonwealth has to, or that they're in his favor, so that we have to make our proof beyond a reasonable doubt, so that in actuality and in appearance, both, the defendant has received a fair trial. But then he said, after some pretrial motions and some post-trial motions, and I think he said 1 or 2 levels of appeal, that is when the presumption of finality in the Commonwealth, the people's interest in finality, comes to the fore. We're way beyond 1 or 2 levels of appeal. And you can't keep coming, or shouldn't be allowed to keep coming back every 5 years saying, hey, I've got another theory. It's not like he came in with DNA. It's not like he came in with anything concrete. It's the same old, same old, same old, only now Maria Ramos isn't alive. There are a number of errors that have just kind of crept into the case over the passage of time, just probably partially the result of the passage of time. But it's not new, it's not newly discovered. The standards that are applied in federal court as far as how a judge considers this holistically and how we consider evidence on a motion for a new trial, the defendant's burdens of showing that it's admissible evidence and showing that he had made a reasonable effort to try to get this before the court before. He fails in those burdens. And 29 years later, the Commonwealth is definitely prejudiced. He doesn't even tell us whether or not any of these other witnesses are alive or could be there. Otherwise, it would be a reading of transcripts. And should it be allowed that he would read the transcript from the federal court when the people who have an interest in trying this defendant, not seeing whether or not procedurally defaulted claims are reviewed by a court? It's a totally different interest that evidence was offered for. It conflicts with what she told people in 1999. It conflicts with everything that we know. And the evidence against this defendant is strong. He's the last person to have been seen with the victim. He was seen at 12:45 outside the victim's apartment. He was seen in the car that was identified as the car that he borrowed from Archie Vernal. He called up later. The footprints, Mark Grant testified that the footprints from the footwear that was obtained from him were similar to the prints on that tile. And he was asked whether or not you inspected the car, the rental car. And the only blood that was detected in the car was occult blood. And it was only on the driver's side or places where you would expect to see a driver touch that car.
Can I ask you about the sole of the sneaker? I seem to remember, you know, and I think Judge Sarah says that the state court, this is at Record Appendix 335, the state court also found that a comparison of the pattern of the sole of the sneaker with the marks that were found in the victim's apartment with bloodstains shows that there was no similarity. Oh, I see. This is between Mr. Small's sneaker and that of the marks found in the apartment.
That's right. The judge, Judge Simons, the trial judge who heard the first motion, and you can see it for yourself at page 141. There's no similarity.
Ms. Dillon, thank you. Your time is up.
Thank you very much.